Hi guys, this is probably gonna be the most boring movie you ever saw, but I think I do need to explain it. I have been getting some questions about copyright, and I have recently got a battle on my hands where for the first time somebody actually recreated something I made and put it up in another language on YouTube. So I needed some advice. I called a lawyer, and he told me a couple of sites that I needed to go to and check it out and see, you know, if I would start a lawsuit, what my options are. Okay, now what does YouTube say? Let's start with that. What does YouTube say about copyright? And we're going to go deeper into that with all the law terminations and all that kind of stuff. But YouTube says, because I'm on YouTube, when a person creates an original work that is fixed in a physical medium, he or she automatically owns the copyrighted work. The owner has the exclusive right to use the work in certain specific ways. So I have the exclusive right. Basically, that means even though I teach you how to make a video, you're not allowed to go out and sell it. Now, of course, you guys know that I always say, yeah, go out and sell it, you know, give workshops, take it to fairs, whatever, and just make money, you know. I don't mind you making money, because that's really what I want you to do. I want you to pay the bills. But what I really don't want you to do is upload a video in a different language where you completely take my video and with your own hands and your own camera, of course, in your own home, make the exact same copy of my work. Now, to also make that, separate that, there's a lot of work that I perfectionized that I thought, you know, if you wear it like that, it's gonna fall apart. So I added this and I added that and blah 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 blah. But let's say, for instance, the Art Deco earrings and you know, the things I've been doing for the last year, basically, those designs. And I'm not talking about the stitches, because the stitches are just stitches, but the designs I all made. You know, I've been sitting here working on them and boggling my brain and banging my head against the wall, and sometimes it would take me hours and hours. So I'm gonna take, for example, the Art Deco earrings that I made, and that's my design. So I have an exclusive right to use them in certain specific ways, okay? And nobody else has the right, that's what it says here, to use them in any way. Now, what types of work are subject to copyright? So we got audiovisual, we're not there, sound, no, written work, no, visual work. That's probably what we would fall under according to YouTube. But that's not the one, not the original one. When we get to the law, this changes into intellectual property. But basically it's the same. So like paintings, if it's a painting or a poster or advertisements or something like that, that would also your jewelry would also be under here. Now, video games, we're not part of that, and dramatic work, well, yeah, some of my work is pretty dramatic, but okay. Now, on YouTube also says ideas, fact, and processes are not subject to copyright. So, I have an idea, and then that's too bad. Could be a fact, and I might be processing it, but they're not subject to copyright. In order to be eligible for copyright protection, a work must be both creative and fixed. Okay, so when my earrings are in the process and are done, then then you know, I own copyright. But YouTube is not quite right here, because the law says something differently. The ideas, they're right on, the ideas in fact are right on, but the process, as soon as you start the process, you put it on a piece of paper, you already have copyright. But that's for later on. Names and titles are not, well, not by themselves anyway, subject to copyright. Now, people wonder if they can use copyright without infringing, and that's also something that's on YouTube, and in some circumstances they can. You can read the fair use for that. You just Google fair use on YouTube. You just Google fair use and YouTube behind that, and you will find that whole agreement on fair use. But we'll talk about that later also. But right now, this is just YouTube and not the law as stated with everything on it. Now, a YouTube's video still can be claimed by a copyright owner, even if you have, and here's where a lot of people make mistakes, given credit to the copyright owner, refrained from monetizing. Notice similar videos that appear on YouTube, so I could let maybe 6 people slip by and just get the 7th one, because I'm, you know, sick and tired of all these videos, all these Art Deco earrings out there, and say like, okay, I've had it and I'm gonna take this one down. So, just so you know, you're never safe. Purchased the content on iTunes, well, that's not for us. Recorded content yourself from TV, not for us. So, well, basically, if you put the YouTube video on TV and then you tape my video and you re-upload it to YouTube, then you can still be claimed by the copyright owner. So, and even if you state no copyright infringement is intended, that means absolutely nothing. Now, let's go to the legal dictionary, and this is where the lawyer sent me to, and to go check it out in English, because the lawyer I talked to is like an international lawyer, and he said just if you need English, go to the legal dictionary. Okay, so I did. Right now, I found out that when somebody copies my videos or copies my designs in any way that I'm not okay with, it falls under the civil rights law. And it says intellectual property describes a wide variety of property created by musicians, authors, artists, and inventors. So that's what we fall under. We are artists. That's what we are. The law of intellectual property typically encompasses the area of copyright, patents, and trademark law. Now, we don't fall under patents, we don't need that, and we don't fall under trademark law either. We fall under copyright. These rights allow artists to protect themselves from infringement or the unauthorized use and misuse of their creations. The copyright and patent concepts were both included in the U.S. Constitution under Article 1, Section 8, Clause 8 of the Constitution. The Congress shall have the power, etc. So, the bulk of intellectual property law is contained in the federal statutes. Copyrights are protected by Copyright Act. Okay, and then we have the law number, so you can look this up. You can just kind of copy this and put that in Google, and it will pop up these SCA sequences, or whatever they're called in American. But so this is the official part. We are definitely protected. Now, cross references, art law. Okay, this is also out of the what was it called? Legal dictionary. Art law. Intellectual property laws give owners the exclusive right to profit from a work for a particular limited period. For copyrighted material, the exclusive rights last for 70 years beyond the death of the author. So for 70 years after I die, which will be like, hopefully at least minimum 100 years from now, my relatives have the right, so that would be my cousins and my nieces, and to say that those Art Deco earrings still have copyright on them because my great aunt made them. Okay, so 70 years. Intellectual property laws do not fall in the category of criminal law, not per se, but some copyright laws authorize criminal penalties. But by and large, the body of intellectual property law is concerned with prevention and compensation. Okay, both of which are civil matters, hence civil court. This means that the owner, not the government, is responsible for enforcement. So, if I want to protect my copyright violation, I need to take it to court, because the government won't do it for me. That's pretty simple. Kind of logical too. Intellectual property laws provide owners with the power to enforce their property rights in the civil court. They provide for damages when unauthorized use or misuse, and that means unauthorized when I don't give you permission, use or misuse has occurred. They also provide for injunction or court orders to prevent unauthorized use or misuse. The property protected by the copyright law must be fixed in a tangible form. We already got that part. For example, a musician may not claim copyright protection for a melody unless it's been written down or somehow actualized and affixed with a recognizable notation of recording. There, I just recorded a sound. That's what a musician needs to do. He needs to record the sound, and that's all there is to it. Copyright laws grant to authors, artists, composers and publishers the exclusive right to produce and distribute expressive and original work. Would you say this is original? I would say. Only expressive pieces or writings may receive copyright protection. A writing needs to be words on paper. A book, right? You want to write a book? It's got to be in paper. In copyright law, it could be a painting, sculpture, or other work of art. Jewelry. The writing element merely requires that a work of art before receiving copyright protection must be reduced to some tangible form. This may be on paper, on film, on audio tape, or any other tangible medium that can be reproduced. Okay, here's my, instead of doing it on paper, I doodle, so I don't draw a design, I got doodles. So here are my doodles. And if this was the first one, it's copyrighted. You see that it kind of stays the same. And here's my finished product, right next to it. So this is already protected, although it hasn't become that yet. But you can understand what I'm saying. It's got to be on paper, on film, on audio tape, or any tangible, in this case, pictures. Put the pictures up on Facebook and you have a date. Because when you put a picture up on Facebook and you leave a comment with it and somebody else leaves a comment with it, automatically you got a date. When you upload a video on YouTube, it will automatically tell you the date, what date was uploaded. Copyright material can receive varying degrees of protection. The scope of protection is generally limited to the original work that is in the writing. For example, assume that an artist has created a sculpture of a moon. The sculpture may not prevent others from making sculptures of the moon. However, the sculptor may prevent others from making sculptures of the moon that are exact replicas of his own sculpture. So, let's put that in picture thoughts. This is my sculpture. You cannot make this sculpture. Now you got an exact replica of my sculpture. But what if you make an exact replica and you use blue beads instead of white beads? Well, then it's still an exact sculpture. You just used blue beads. Because if the sculptor who made the moon painted it yellow, and the guy that made the exact replica made it green, it is still the moon sculpture of the sculptor that was exactly copied by the one that did the replica. So it doesn't matter if it's blue or white. What matters is that it's different. Now it's a little different here. We got, for instance, a little hook, and we have blue beads, and we have big gold beads in there, and it's got a little bit of a different color to it. And this one is a white one, and it has white beads on it as a loop instead of this headpin in there. So you could take this to court and claim fair use, but I'll doubt you will get it because they are too much alike. You can still see that that's the same sculpture, so to speak. Now, copyright protection gives the copyright holder the exclusive right to 1. Reproduce the copyrighted work. That's here. I reproduced it. I can do that. That means I got the exclusive right. I can do this. You cannot. Officially. Now, we also have the exclusive right to create derivatives works from the work. That means I made this one a little different, more different, even more different. So, I can do that. You can not do that. I also have the exclusive right to distribute copies of the work. Yay! And we're on Etsy. I am selling the earrings, or I'm selling the patterns, and you know, these are all copies of my work. I have the exclusive right to perform the work publicly. And here we go. Now we're on YouTube. I have the exclusive right to perform the work publicly. This means if you take one of my videos and you redo my pattern, which I have copyright to, you are redoing my work, and you cannot do that because I have the exclusive right to my work. And even if you would change the color of the bead and still make the exact same copy of my video, so if you make this in the color purple, it will still be my work, and you're not allowed to do that because only I have the exclusive right to perform the work publicly. Okay? And I also have the exclusive right to display the work. Okay, so that means that I can give workshops. Now, the first two rights are infringed whether they are violated in public or in private. Now, what is infringement? Copyright infringement is the use of a work protected by the copyright law. So, you're using my work that is protected by the copyright law without permission. Okay? So that means if you go on YouTube and you put a video on there making these exact same earrings in purple, you are violating copyright. You're infringing it. It's the use of the work protected by the copyright law without permission, infringing certain exclusive right granted to the copyright holder, such as the right to reproduce, distribute, display, and perform the protected work. So, then we just had that whole list of 5 again. Or was it 1, 2, 3, 4? Yeah, okay. The first one, what's the first one again? The first one was reproduce, make the derivatives, distribute, perform the work publicly, and display the work. Okay. So now that we got all that, basically, there's not much you can do. You can watch the video and make a couple and give them to your friends, or you know, that's basically it. And when you think really hard about the copyright law, that's what it's saying. There's basically nothing you can do. You can make one for yourself, because I put it out there publicly. That's all you can do. But we're not gonna go play that game, so because that's just too harsh. But under the current law, copyright protection begins with an eligible work. So let's get through it again. For like, how does a work become copyrighted? It needs to be fixed in a tangible medium of expression. So here's that picture again. Such as being written on paper, recorded on film or disc. Contrary to popular belief, it is not necessary to register a work with the Copyright Office in Washington or wherever else in the world in order to copyright it, nor is it any longer necessary to include. However, you know, it could be handy to, you know, when you see that little C, you know it's copyrighted. Now, how do you get permission to reproduce or disseminate someone else's copyrighted work? Well, you find the copyright owner and you ask. That's very simple. All you have to do is ask. Now, they can say no, but they might say yes. You never know. There are no special forms that must be used, and permission can be oral or written. Though it is good practice to obtain permission in writing, the copyright owner is free to charge whatever fee or he or she wishes. Through the user is likewise free to try and negotiate, though the user is likewise free to try to negotiate a lower fee. So that means if somebody wants to re-upload my video in Nigerian, and they say, well, I want to use I want to do exactly the same as you did, I just want to talk Nigerian language, because there's so many Nigerians watching YouTube, and I want to do this in Nigerian, if that's even a language, then I can say, well, that's fine, you can do that, it will cost you $100, for instance, I could say that. But I don't want my videos on YouTube in any other languages. Yeah, that's the only thing that I really don't want. Okay, now going to the YouTube terms of service. This is when you set up your YouTube channel and you think, okay, I got all the copyright stuff, I got it, and I'm gonna go on YouTube now. There are some terms of services that I picked out that I think you need to know, because they also have to do with copyright. You agree that you will be solely responsible to YouTube and others for all activity that occurs under your YouTube account. And don't forget that you're going to sign this at the bottom. So that you are solely responsible. Nobody else is, you are. Okay? So if you if you steal somebody else's pattern and you upload it and you get flagged, you are solely responsible for that. General restrictions on use. Okay? 5.1. YouTube hereby grants you permission to access the use of the services, subject to the following express conditions, and you agree that your failure to adhere of any of these conditions shall constitute a breach of these terms on your part. Now there's a lot of, it goes from A to M, but M is the most important for the ones that are trying to fight the copyright infringement. So, you shall not copy, reproduce, distribute, transmit, broadcast, display, sell, license, or otherwise exploit any content for any other purpose without the prior written consent of YouTube or respective licensors of the content. Now look at this. I have a standard YouTube license right here. So that's me. When you go to my channel and you see my video, it will say standard YouTube license. If I would put it on Creative Commons attributions, you can do whatever you want with my videos. You can download it, you can subtitle it in Spanish, you can do whatever you want. But I haven't given you that permission. I am standard YouTube license. So that means unless I will give you permission, written consent, to be specific, you're not allowed to do anything. So, not with my videos anyway. 5.2, you will agree that you will comply with all the other provisions of terms on the YouTube community guidelines at all times during your use of service. And I also thought that is important because you comply with it, you say, yeah, I won't steal anybody else's video, or I won't reproduce somebody else's design, then, yeah, that's basically what you're signing to. Copyright policies, also one from the YouTube terms of service. YouTube operates a clear copyright policy in relation to any content that is alleged to infringe the copyright, and here we go again, infringe the copyright of a third party. Details of that policy can be found here. You can look that up. YouTube, well, I'm on UK right now, but just put in copyright notice on Google and you'll find it. As part of YouTube's copyright policy, YouTube will terminate user access to the service if a user has been determined to be a repeat infringer. A repeat infringer is a user who has been notified of infringing activity more than twice. So that's 3 times, 3 strikes, you're out. Now, if you upload for 40 videos in a time span of 2 months, I don't think you quite read this if those 40 videos all obtain copyrighted material. But you signed it, and if you upload 40 videos anyway in a time span of 2 months, you're not in it to enhance the world, but you're in it to make as much money as you possibly can as soon as possible. And if you do that with other people's patterns, then yeah, I don't think you have a right to be on YouTube. But, you know, opinions might be different about that. So, fair use. Fair use. Let's talk about fair use because, you know, I put out a copyright claim on the video and I got a fair use claim back. Now, let me tell you why she has no luck, because what she did was, she did this. Right, this. This is mine, and that's what she did. She just changed the color of one bead. Other than that, it's exactly the same. Well, maybe there's another clasp on there, but it's exactly the same. And we're going now to fair use. Can she claim fair use? No, she cannot. The purpose of a character of the use includes whether such use is of commercial nature or non-profit educational purpose. Well, it is of commercial nature because she put AdSense monetization on there. So, she's using it commercially. Court typically focus on whether the use is transformative. That is, whether it adds new expression or meaning to the original. No, it does not. It's in Spanish, but it does absolutely not add new meaning to it. Of course, that's up to a court of law if they think it's got new meaning to it. Or whether it's merely copies of the original. So I think that's going to be the one. It's going to be seen as a copy of the original. Commercial uses are less likely to be considered fair. Well, yeah, so that's already, then she's got like two problems because she's trying to make money, so she's using it as commercial. Though it's possible to monetize a video and still take advantage of the fair use defense. So, you know, could go either way, but it doesn't look good. The nature of the copyrighted work. Using material from primarily factual work is more likely to be fair than using purely fictional work. Yeah, I don't know exactly what to think of that, but yeah, I don't think she's gonna win with that one either. The amount and substantial of the portion used in relationship to the copyright work as a whole. Well, let me put it, the whole design was made and copied, so there's not even a portion, we're not even talking about a portion, so she can't go on this one either. The effect of the use upon the potential market for or value of the copyrighted work. So that means uses that harm the copyright owner ability to profit. Now, if you monetize a video that, let's go back to my Art Deco earrings. If you redid my Art Deco earrings in purple and you put them on your video and you monetize them and you even as much as make 1 cent of them, then you are harming the copyright owner, me in this case, because I'm not profiting, you are profiting. So that means the money you make, I should be making. So that's it's all really harsh, but that's the way it is. That's what the copyright law says. From his or her original work are less likely to be fair uses. So you can't claim fair use there either. If you use the copied work in a way that substitutes the original in the market, that will weigh against fair use. So, okay, I think that's pretty clear. If you use the copied work in a way that substitutes for the original in the market, that will weigh against fair use. Yeah. Anyway, courts have sometimes made an exception under the factor in cases involving parodies. Well, I don't think the design is a parody. It's okay. Now let's go to the myth. People seem to believe these. Myth 1. I give credit to the copyright owner. My use is automatically fair use. Not. Myth 2. If I post a disclaimer on my video, my use is fair use. Not. Myth 3. Entertainment or non-profit uses are automatically fair use. Not. Myth 4. I add any original material I created to someone else's copyrighted work. My use is fair use. So I got the original and I put something extra to it. Or maybe took something away. And then, therefore, it's my fair use. So, these are my little Christmas trees. And here you took 2 layers off. And now you consider it fair use. And I make a netted necklace. and you decide to put on the ends pearls, add any original material I created to someone else's copyrighted work. Can you see how tricky that one is? So even if you add to it, even if you make it better, you still can claim fair use. So that's basically it. I hope you liked it, and you know, I'm not that rough. I'm just putting the basics out so you exactly know what you're against. With this video I also say I want you to recreate them, I want you to sell them, I want you to make money, I want you to give them as gifts, I want you to do workshops with them, I want you to teach it to other people out there in the world, I want you to make money with my patterns. The one thing I do not want you to do, and I keep saying that, is upload my video in a different language. Do not take my little pretty Christmas tree here that I designed myself and upload it in a different language, and even though it's your hands, even if it's your camera, even though it's your beads, it is still my design. And I want you please to stay away from that design, because I really don't want to have to fight or go to court just to get somebody to keep their hands off my design. Any other way you want to do. You want to sell kits? Go ahead, sell kits. Whatever, you know, just don't touch the designs as they are put on YouTube to go on YouTube yourself, or on Dailymotion, or on any other video place where you can make your own videos and upload them and monetize them. Just don't do that. I mean, I think it's fair enough to ask that, and I really don't want to get caught in all these, I don't want to get caught in lawsuits with people over this. So that's all I'm asking for. But I hope you enjoyed it. I hope that you understand how strict the copyright law is. And if somebody says, I don't want you to, then that's their right. I mean, it really is their right. I'm going to try and see if I can turn this into a PDF and... there's no way I can leave this underneath the video because it's not a link. I have to upload it somewhere, and I'm not really sure where I'm gonna upload it. But if you want a copy of this, then feel free to mail me at beatingforperfectionist@yahoo.nl, or find me on Facebook, yeah, and send me a PM there if you want a copy, and I will get it to you for sure. But yeah, that's all there is to it, and I hope you enjoyed it. And as I said earlier on Facebook, I didn't know I had that many rights, but it's kind of scary, isn't it? It's very, very scary. All I can say is I'm very easy about it. I don't care if you go out there, sell, and do all kinds of stuff, but if, like with somebody else, please, please, please ask first, because that's basically the only thing that people would want, is ask. And if they say no, then, well, then it's no, don't do it. And if they say yes, then, you know, you're lucky. So go ahead, go out there, and be careful with the copyright. Bye.